I am the president of Lawton & Cates, and I am thankful that you could all make it this evening. The purpose of our meeting is to go over information regarding the case You All against Kraft, for which you have been victorious. So round of applause for victory. To start off, I'd like to talk a little bit about the history of Lawton & Cates. John Lawton, who is one of the founders, is actually the author of the law that allows public sector unions to collectively bargain. Yes, thank you. So we definitely feel like we have a vested interest in supporting unions during these difficult times, and I can assure you that our attorneys and even our staff are out there at the Capitol supporting you and trying to help protect those rights to collectively bargain. May we be victorious in that as well. This morning we spent, four of us spent the morning bowling with your IBEW brothers and sisters and then went up to the Capitol directly thereafter. Glad to be with you now. All right, so I know that in the words of Jerry Maguire, you are all interested in hearing, show me the money, all right? We're going to get to that, but we're going to walk through it in a progression. I'd kind of like to walk through what's happened with you and your case, and I'm going to generalize, and then we're going to have the attorney who's the lead counsel now walk you through where we are now and what we need to do to get you to those checks, get those checks to you. Kurt Colbelt was our longtime labor union lawyer, and he is the one who started this case for you. I know many of you have worked with Kurt. He got this case rolling. Probably the next lawyer who had a substantial stake in it was Heather Kernut, and Heather's here. Go ahead and stand up. Jim Olson will talk a little more about all of the work that Heather did for you. Also, when Heather was working on it, we also had Doug Phoebus working on this case. He is not with us any longer, but he represents your union president, Joe Jerzewski, and so he is still working in tandem with us. In the middle here, we have many of the lawyers. First of all, Sarah Siskin, who's still with us and has been on this case since Kurt Colbelt was working on it. Instrumental part of our team. And then I would like to introduce you to Jim Olson. Jim Olson is one of our senior partners at Lawton & Cates. He is our go-to guy when we have complex litigation, and when we needed someone to take this through the final chapter and get you to those checks, Jim Olson is the one who stepped up, and from Lawton & Cates, he is the lead lawyer in this case, and he's going to talk to you about how we get from here to distribution of the checks. So I'd like you to give him a warm welcome. Sarah, I think I'd like you to come up here as well. Give a warm welcome to Sarah and Joe.
Okay, thank you, Ginger. Yeah, this case is a lot of fun for me because all of the heavy lifting was done by other people. First, it was Kurt Colbelt who put the case together, and for a couple of years, and won just about every battle that needed to be won, and then realized that we still had to be able to prove your damages. Although we proved you had a right to get the money, we had to figure out how we were going to do it, and with over 1,300 people, and different donning and doffing times, different wages, and different hours that you worked, it got to be a huge problem. And Kurt very fortunately knew Sarah Siskin, who's a lawyer in Madison with the firm of Minor, Barnhill and Gallant, and she had a great deal of experience in working on putting together that kind of thing. And so she got a computer data expert who was able to do that, put that together, and between the two of them, they put it together so well that the court accepted it, and so did Kraft accept it, and that will be the basis upon which you'll be paid. Sarah stayed on the case after, well, Heather argued the case in the 7th Circuit Court of Appeals, and that was a major part of the case as well. The case had been won in the district court in front of Judge Barbara Kraft, but of course Kraft didn't give up easily. They appealed it to the Seventh Circuit, and Heather went down there and argued the case in front of the judges, the three-judge panel. And that is a rather frightening environment for any lawyer to do. There are three judges. They pepper you with questions. And in this particular case, the chief judge was a judge by the name of Easterbrook, who was a Reagan appointee, and during the Bush years was on the short list of appointment to the Supreme Court. A very bright judge, a very aggressive judge, and a very conservative judge. And Heather stood up and answered all of his questions, and after what seemed like an awfully long period of time, we came back and she had won a great victory for us. And Judge Easterbrook wrote the decision. After that, Kraft still didn't give up. They could still argue that the Supreme Court should take it, and so they petitioned the Supreme Court. And that's when I met Sarah. I knew she'd been involved in the case for a good while, but we talked to her, and Sarah and her law firm had done a lot of the work on these kinds of petitions before to the Supreme Court. And so we worked in tandem with her. Doug Phoebus, we kept Doug involved, and we asked him to provide us any input, and we took it to the Supreme Court. So I'd like to, do you have any observations about the legal process before we go into how we're going to
about how we, well, it's been a terrific, I'm grateful for having been called into this case. It was interesting, wonderful lawyers to work with. Jim's been wonderful, Kurt was wonderful, Heather was wonderful. These things take a lot of time that you sort of might wonder what takes us all this time. But there are legal issues, briefing, we're very slow. It's a huge effort, and when you have good, responsive, congenial lawyers to work with, it makes a huge difference. The issue that the Supreme Court was looking at, and this is important for some of the questions that many of you have been asking, one of the issues I think Jim is going to address is what rights are at issue in the lawsuit. Are they rights about your rights under your collective bargaining agreement, or rights about your or rights under the Fair Labor Standards Act? One of the many things that the union movement has brought to us is that it's brought general statutory rights for everyone, including the Fair Labor Standards Act, the wage and hour laws, even independent of collective bargaining agreements. In your situation, you have had the strength and intelligence to get yourselves represented by a union. And so in addition to these general laws, you've got a collective bargaining agreement that provides rights above and beyond what the Fair Labor Standards Act provides. In order to pursue this particular claim, however, we needed to persuade the court that we were vindicating only the general, the FLSA's, Fair Labor Standards Act claims. And that law provides for compensation for all time that you work, which included, in this case, your donning and doffing time, the time that you needed to take to put on and take off the protective gear and walk from the places where you were required to do it to your workplace, for which you had not been paid. The Fair Labor Standards Act required that that be paid, but because of a quirk in the law, there was an issue about the difference between what the collective bargaining agreement required and what the statute required, and it was important for us in resisting the Supreme Court review to show them that the laws that we were not seeking, and we could not have been seeking to enforce the collective bargaining agreement because it didn't provide for this time. We were seeking simply to give you the statutory rights. That's the Fair Labor Standards Act rights, which gives you all pay for all of your time worked, independent of the collective bargaining agreement, plus time and a half over 40 hours. which is very different from what your collective bargaining agreement provides. Better in some ways because it gives you the time for donning and doffing, but less advantageous in other ways because it doesn't give you the premium pay that you get, the double time and other premium pay you get. But that's what the case was about, and what the Supreme Court was looking at was it wanted assurance that that's what we were looking for, not because if we had been seeking to enforce a collective bargaining agreement, we would have, our claim would have been rejected because we didn't have authority under the FLSA to do that. So that's one of the kinds of issues that we needed to brief and that we needed to research, and that was a little tricky in getting us through the appellate process. But we got there, and we're here now.
I'd like to point out that you had 4 class reps that were working very close with the law firm, and I'd like you to give a round of applause to Jeff Sporley, Jason Knudsen, Nick Lee, and Kathy Smith for their work. Yeah, why don't you stand up? I know we have a couple here. Jeff, Jason, thank you.
It may have been a tower of strength throughout this case. You know, we've had questions about how things were going on. We've always contacted them. I know that many of you have contacted them, and it's been a very good relationship. Now I'm going to call Heather up here. She wasn't. I'm not sure she wanted to, but she should at least come up here and say hello because she is one of the real stars in this case.
Thank you. It was a pleasure working on the case, and I'm glad we got a great result for all of you.
Very concise, to the point.
Okay. We've handed out this document. What the document is the notice of the proposed class settlement that was, you all should have received a copy of this back in 2009. As the case was getting close to going to trial, this was when Kurt was working it, there was a settlement that was achieved. Sarah was involved very closely in the settlement negotiations. And the settlement was really vital as far as this case was concerned. It wasn't a total settlement. We still had to win on certain legal issues. And like any settlement, you know, there's give and take. But the important thing was that if we won on the legal issues, that we had a plan for settlement in place. And as I say, you were given notice of this and a chance to object if you wanted to. And in fact, objections were made to certain part of the settlement. One very important objection, which was, which Joe Drzeski and others in the cafeteria workers said, hey, the cafeteria workers weren't included in this settlement. And frankly, that was an oversight, and it was fortunate that that was brought to the attention so they could be included in the settlement. And we negotiated that as far as the settlement was, as far as the payments were concerned, Kraft would have to pay 2/3 of the donning and doffing time to the cafeteria workers, but we would forfeit a third, we would pay a third towards their amount so that they will be compensated like everybody else. But aside from that, the settlement was approved by the court, and so now it's really cast in stone. I mean, the settlement has been approved, and what we're going through now are the mechanics to make certain that you get properly paid. Now, the question, I have probably had 100 phone calls or more at the office, and the questions are basically two. When will we get paid and how much? And those are very legitimate questions. And first off, let me tell you when you'll get paid. And like most lawyers, I'll have to say that kind of depends. But my best guess